All right. Hey, everyone. Welcome to our third and last webinar that we're hosting in conjunction with our partners at Oracle for Startups. Today we have Carl Hessler, who is also a OneValley mentor, who will be running a webinar for us on the legal pitfalls to avoid when raising venture capital. Before we get started, I would just love to give everyone a quick overview of Passport. So Passport's the world's most comprehensive digital innovation platform, connecting entrepreneurs and emerging startups with access to vital resources, networks, and significant savings on essential business tools. We have over 25,000 global members, 140 mentors, such as Carl, and 450 investors in our investor forum, as well as $1 million in discounts and services in our perks. Today, we will be raffling off a free year of Passport. So make sure to stay on until the end. We'll announce the winner at the end, and then we'll get in touch with you on how to redeem. So with that, I'm going to pass it over to Rohit from Oracle for Startups.
Thank you, Kara. Hi, everyone. Good morning, good afternoon, and good evening. My name is Rohit Jain, and I'm the North America Business Development Lead, Oracle for Startups, based here in San Francisco, California. I'm excited to hear from Carl Hessler from Lowenstein Sandler, discuss a really important legal topic today, raising venture capital financing and legal pitfalls to avoid. In the past year, I was reading some data, over $200 billion were raised globally, and this is something that I think will continue to rise, so I'm really excited about this. Oracle for Startups puts on many different workshops to support the startup community. And then this has just been this has been a great workshop series with OneValley and Lowenstein Sandler. Additionally, I'm also a OneValley mentor. I'd love to just give you a brief overview of Oracle for Startups and how your startup can benefit from our program. Kara, if you can move on to the next slide. So today, startups have multiple options for which cloud provider to utilize. Value, performance, and security are just some of the most crucial factors. And they're just a few of the reasons why startups choose Oracle Cloud. Last month, I spoke to a startup that saw their cloud bill rise and decided to migrate to Oracle. And in today's startup environment, every dollar of savings matters, and we save the startup over 70% off their cloud. Oracle has 430,000 enterprise customers, and for startups in our program, you potentially get the opportunity to get in front of them. We don't take any equity and don't charge any fees. And lastly, on the next slide, and any startup can sign up. It's open to startups and innovators worldwide. For any questions, please feel free to email me. I'll drop my email in the chat, and we'll love to have you join our program. It's really easy to get started, and you just have a short application to fill out. And let's get rolling with Carl's presentation. Thank you. Passing it over to Carl.
Great. Thanks, Rohit. Appreciate it. Just going to pop my slides into the view. Hopefully everybody can see that okay.
Yep. Carl, you don't have your video on, just so you know.
Oh, thank you. Let me fix that as well.
Perfect.
All right, perfect. Hey, everybody. So welcome. Thank you for joining this third installment in the series. I'm looking forward to talking to you a little bit about startups and venture capital. Thanks again to our friends at OneValley and Oracle for Startups. Rohit, appreciate it, all the support, and the entire team at OneValley for helping to put this series together. My name is Carl Hessler. I'm a partner in the tech group at Lowenstein Sandler, where I've been for 10 years working with startups and venture capital funds and representation of both startups and VC funds in those sorts of transactions. The firm is a general services firm. We do all kinds of stuff. And in the tech group, we are generally, in the top 5 law firms in terms of number of venture deals every year closed. I've personally closed hundreds of them in my career, and can tell you all about the issues I've seen in the course of that time. I'll be going over some, topics on startup and venture capital today, some things to avoid that I've seen cause problems in those transactions and in the lead up to those transactions. We'd love to make this sort of an open discussion, so feel free to drop questions in the chat as things come up, and I'll do my best to answer them in real time. If not, we'll address questions at the end. So I'm going to go to my next slide here. 1 second. So, I wanted to start off the presentation really by talking about, we're sort of talking about a narrow scope. I could do lots of presentations on various topics within venture capital and startup, but I'm looking sort of to narrow the scope here to define what we're trying to achieve. And that really is, structuring your company and growing your business in a way that does not impede your ability to raise financing and to grow your business further. And you want to grow the business, get to an exit, and to do that, you're going to need financing along the way. And to the extent you're set up to do that efficiently and to process a smooth transaction, that's going to bring down costs for you. It's going to make you look good to your investors. And so that's that's sort of the thing that I'm focused on here. And I'm going to talk about some of the things that I've seen that kind of can get in the way of that. Things you want to look at, from square one are what's the company's timeline. So what are the company's capital needs in the short term and in the longer term, and you really want to build that into your business plan. You're optimizing in a lot of ways for attracting capital and talent and really facilitating liquidity ultimately. Does the company have plans to issue equity to employees and other advisors along the way? That's an important question to address. Typically, the answer is yes for all startup companies. And really, allowing potential investors and acquirers to focus on the merits of the business and the quality of the team, and not kind of be distracted by, the legal issues that may not have been addressed in the lead up to those sorts of transactions. And those are the sort of things that can get in the way of a successful transaction. Once you've been through a pitch and get to a term sheet with an investor or an acquirer, things start moving pretty quickly. And to the extent, the company has due diligence issues or things like that, or the company doesn't quite have all of its ducks in a row to put its best foot forward in a diligence process and get to closing a transaction, those things are going to delay your deal, add costs, and potentially not put you as founder, co-founder, whatever your position is at the company, in the best light. So let's get to some of the substance here. Next slide is about choosing the right entity. And we see things all over the map here, but generally, you're going to want to form or ultimately end up in Delaware as a C corporation, not an LLC, not a partnership. The world of startups is really the world of corporations, and by and large, those are being formed or converted into Delaware corporations. You can start as an LLC and convert into Delaware later, but if that's the case and you're ultimately aiming towards venture capital financing, you want to keep the entity as simple as possible as an LLC, meaning no investment, no other employee equity until after the conversion into a Delaware LLC, into a Delaware C corporation. The reason for that really is the complexity that you see once you start layering in equity in an LLC. Just gets very tax complicated. And then once you want to convert it into a Delaware corporation, much more difficult to do so than if you're just a single or you know, got a couple members in the LLC before you convert to a Delaware corporation. LLCs are really geared towards, you know, private equity funds, sort of the, you know, more complex financing structures, real estate, that sort of thing. And we tend to veer away from them in the startup world for a number of reasons. And Delaware C corporations are sort of the tried and true corporate form. The reasons behind that I can go into greater detail, but I'll just mention them quickly. You know, the LLCs have extremely complicated tax partnership rules. You know, there are capitalization and capital raising issues, sort of like I mentioned. Basically, you know, it's very difficult to issue an equivalent of an option grant in an LLC, whereas it's super simple to do in a C corporation. You can't really do convertible notes in an LLC. Again, very simple to do in a C corporation. Venture capital funds generally avoid investing in an LLC or a pass-through entity, and you know, will make it a closing condition to a potential financing transaction that you convert to a C corporation, typically in Delaware. So you know, a lot of those things can be addressed up front, and you can avoid a lot of complexity and difficulty by just going with a Delaware C corporation initially. That said, there are reasons that you might want to stay as an LLC initially. You should just talk to your legal advisor and your tax folks to sort of understand, you know, exactly what you're doing there. Another one of the issues that comes up with an LLC is that vesting of founder stock is very, you know, is much more complicated to do in an LLC, and you know, it just generally doesn't get baked into the formation documents in an LLC, and that can cause problems if the LLC is not converted, and I'll talk about that a little bit in the next slide. So, you know, Delaware is where you want to be. C Corp is where you ultimately want to end up. And I just want to touch on the election as an S corporation is something you also want to avoid. It's essentially when you form as a C Corp, you're electing to be taxed as an LLC. You make an S election, and that can cause, that does cause problems for QSBS treatment, which I will touch on later in a subsequent slide. QSBS stands for Qualified Small Business Stock, and it's a huge potential tax benefit to anyone who holds stock and meets the required holding period, et cetera. So you don't want to blow that out of the gate. Let's see here. I'm going to go to my next slide. Just got to navigate to that. 1 second. So the next thing I'm going to talk about is founder stock vesting and some of the tax issues associated with that. When you form a C Corp or an LLC, you know, you're generally issuing founder stock, or maybe it's membership interests in an LLC on day one. Please do this with the help of an attorney or someone who knows what they're doing. Seen, you know, this pretty simple process messed up a couple times, and it's not pretty. It ends up being much more expensive for the company to clean up down the road than if it had been done correctly the first time. You know, I can't tell you how many times I've seen it, but it ends up being, you know, 5 to 10x more expensive than it would have been had the company done it right the first time. So definitely would advise getting good help with that. Some of the issues that arise generally are relate to vesting of the founder stock and 83B elections, which I will touch on here. So vesting schedules really need to be put into founder stock agreements when there's more than one founder. It's, that they're intended to protect both the company and the co-founders, and generally venture capital funds who are investing in your company are going to require those things. And not setting up these schedules, these vesting schedules at the outset is really one of the common mistakes that we'll see with companies that come to us in advance of a financing and are, they're looking for help, and the vesting schedule is either non-existent or is incorrect, and it's problematic. It can happen in a scenario where a company is formed as an LLC, like I mentioned. When the company is formed as an LLC, generally, it's vesting schedules don't get baked into the documents because it's a little more complicated to do in an LLC operating agreement. And so, that's one thing to be mindful of. The real problem arises when you've got a founder or a co-founder. There's a team of 3, let's say a team of 4, everybody has founder stock, but one or more of them don't have vesting schedules attached to their agreements, and somebody leaves the company. They leave with all of their stock. They leave with all of their ownership interests if it's not subject to a vesting schedule. And so, that's problematic in the event that the co-founder who's left doesn't want to sell the stock back to the company. It can hold up a venture financing deal. Venture investors don't like to see a big chunk of stock out there held by former team members that are not contributing to the company anymore. So very important to keep in mind. The intent of a vesting schedule is really just to incentivize the co-founders, granting them the opportunity to earn their equity over time. Generally, it's a 4-year vesting schedule with a 1-year cliff, always subject to negotiation and discussion. Sometimes there's vesting upfront so that on day 1, co-founders are given credit for the work they've put in so far. But it's really intended to both incentivize and protect the company and co-founders in the event that somebody leaves. And really, you're not going to see a sophisticated investor put money into a company that does not have solid vesting terms attached. So avoid messing that up. Time consuming, can kill your financing deal. Much more expensive for you to deal with it once a problem has arisen. And so, make sure that gets addressed. One of the other components of vesting that we see all the time is acceleration of vesting. And acceleration of vesting is a fairly standard term for co-founders. It means that if something happens where one of the co-founders leaves for good reason, and that's usually a negotiated term. What does good reason mean? A reduction in duties, company moves its headquarters, things like that affect the co-founder's role or position. Then there's something like that can cause an acceleration of vesting where usually it's not a full acceleration, but some percentage of that. And just making sure that if there is acceleration, those terms all make sense and are buttoned up. Our market kind of standards. What we usually see is a double trigger acceleration provision for co-founders, which says that if there's a change of control where the company is purchased and one or more co-founders are terminated without cause, then all of the unvested equity accelerates, and the co-founder owns everything outright. But absent that, we don't really see a whole lot of other customized vesting terms. So you want to keep an eye out for that in your company's formation documents. So the other really important thing, really one of the most important things about your founder stock is that if it is subject to vesting, you're going to want to file an 83B election. Typically 83B elections are things that are usually attached to your restricted stock purchase agreement as a founder or co-founder. Often, in the event you're a senior employee and you're getting early exercise options and you're early exercising those options, you're also going to want to file an 83B election. It's something you will want or need to discuss with your tax advisor, your accountant, but generally, it's something that everybody who's getting stock that is subject to vesting files with the IRS. Failing to make a timely filing of your 83B election can really lead to disastrous tax consequences for both the company and the employee or founder who's received the stock. So like I just went over, founders typically purchase the stock pursuant to restricted stock purchase agreements. The stock the stock is subject to a repurchase. Basically, it's a vesting mechanism that if the founder leaves, then the unvested stock is subject to repurchase. Under Section 83B of the Internal Revenue Code, the founder or employee that's received that stock that is subject to vesting or forfeiture would not recognize income. This gets a little complicated. Would not recognize income, which is the difference between the fair market value and the price that they've paid for the stock until the stock vests. But if the founder or employee makes a 83B election, then the founder or employee recognizes income upon the purchase of the stock. Typically, the purchase price of the stock and the fair market value of the stock in these contexts are the same. So if an 83B election is made, there's no income recognized. And so generally, typically advise in consultation with your tax advisor to make the 83B election. The benefits of an 83B election generally are starting the 1-year capital gain holding period and freezing ordinary income recognition with respect to the purchase date of the stock. If the 83B election is not made, then he or she may have income as the stock vests. And that can be really problematic because generally the valuation of the company is going up as the stock is vesting in a startup. And you can end up having a whole bunch of tax, a whole bunch of income that is subject to tax on that basis. So let's do a quick example of that. If we assume a founder purchases stock for $0.01 per share and the fair market value is $0.01 per share, the stock is subject to 4-year vesting with a 1-year cliff. The founder does not make an 83B election. At the end of the 1-year cliff, if the stock is worth $1 per share, then the founder recognizes 99 cents a share of income. Generally, founders are getting, 1 million shares, 2 million shares. That could be a whole lot of income on the stock. And as the remaining stock vests each month, the founder recognizes income equal to the difference between the fair market value and $0.01 per share. So if your valuation is going like this, you can imagine what kind of tax consequences you may be facing if you find yourself in a situation of failed to make an 83B election. Not good. We've inherited some clients that have had this issue, had to help them clean it up. Very painful, very expensive. Not a place you want to be. File your 83B elections. In order for an 83B election to be effective, it has to be filed with the IRS either prior to the date of the stock purchase or 30 days after the purchase date. And that's a very hard and fast rule. There are no exceptions to it. So, you know, it's a very important thing to be keeping in mind, and to make sure you get done. Let's see, I've got a couple of questions, it looks like, popping up here. Let's see if I can get to those. Please confirm when the 83B needs to be filed. It's the time of signing initial corporation documents, when the stock begins to vest, or when the owner of the stock sells it. The 83B election needs to be filed within 30 days of the stock purchase. So there can be scenarios where the company is incorporated. Let's say the company is incorporated on January 1st, 2021, but the stock isn't issued to co-founders until February 1st, 2021. You have 30 days from February 1st, 2021 to file your 83B election, and that gets filed in the IRS office where you'd file your personal taxes. Usually your restricted stock purchase agreement is going to include a form for filing and some instructions, if it's a good one, for doing it. You want to keep a copy for yourself to attach to your tax returns. And this really, apologies to our non-US taxpayers, this is generally a US taxpayer issue that you want to be looking out for as a US taxpayer. But if you're a non-US taxpayer, you can also be subject to it in the event that you move to the US and become a US taxpayer within, I believe it's a year, but I could be wrong on the timing. So it's still generally applicable, generally something to be good to look out for. If there are any other questions on 83B elections, happy to address those at the end. One more tax issue I want to touch on quickly. Also very, very important tax issue to be mindful of is, I mentioned it above when we talked about the choice of entity and converting from an LLC to a Delaware C Corp, is qualified small business stock. It's a tax benefit. It's an exemption from federal tax, where if the requirements are met, can potentially avoid up to 100% of the capital gains taxes when your stock is sold. And so, you know, it can be a huge windfall, huge tax benefit windfall for you if the conditions are met. Generally on a sale, business owners, co-founders, stockholders, investors who meet the conditions can exclude the greater of $10 million or 10 times your basis in the stock from federal tax. So huge, potentially huge, and even bigger than $10 million if your basis is something more than zero. So let's go through the requirements really quickly. Generally, there are going to be a couple places where, you know, there are things that are out of your control and things that are in your control. I want you to make sure you're aware of it generally, and to make sure you're aware of the things that are in your control with respect to preserving potential QSBS treatment. Stock of a small business generally qualifies as QSBS, it's qualified small business stock, if the stock meets certain requirements. The requirements are that the small business is a domestic C corporation. So Delaware C corporation, you're good. The taxpayer acquired the stock at its original issue in exchange for money or other property or as compensation for services. That one's generally satisfied, but there are some edge cases where it may not be. The small business is engaged in a qualified trade or business and uses 80% of its assets in the active conduct of one or more qualified trades or businesses. Little complicated, we'll unpack that a little bit. Number 4, the aggregate tax basis of the small business's assets on the date the stock is issued is $50 million or less. So that's sort of the small business prong. If your gross assets are under $50 million, you meet that test. There are a couple of things to keep in mind there. For example, if the company's assets are $15 million and the company raises a $40 million financing round, the stock issued in that financing to the investors would not be QSBS. Kind of a minor point that really, we're talking about, what you as your founders and your employees can do to make sure you're maximizing QSBS potential. So, that's sort of an edge case as well. There are a couple of, so the fifth prong that you want to keep in mind, and this is really the one that's in your control as a co-founder or senior executive of a business, is that while there are some certain exceptions to this one, the small business cannot have made repurchases of any stock within the 2-year period prior to which the stock was issued. And so, there's an exception to that for repurchase of stock that was subject to vesting, repurchase of stock that was, that is in connection with the termination of services. And there's a de minimis exception. It's like 5% of the overall value of the company. If you fall below that, then the redemption would not count towards disqualifying the stock as QSBS. But just keep in mind, it's good practice to keep in mind, given the potential tax benefits, that anytime you're thinking about a redemption or a repurchase of stock, think about QSBS. You don't want to blow QSBS, given the huge upside that you can see from it. Going back to the qualified trade or business prong of this, qualified trade or business is defined as any trade or business other than performing services involving the performance of services like accounting, engineering, or consulting, or any other trade where the principal asset is the reputation of the business or the skill of its employees. So like a law firm, interest issued in a law firm would not be QSBS. Banking or financial businesses, generally not QSBS. But there's like there's sort of a gray area with respect to fintech companies that really kind of comes down to a factual analysis and determination about what the company's actually doing. Farming business is excluded. Mining, oil, or gas business, or any business operating a hotel, motel, restaurant, or other sort of hosting business would not be QSBS eligible. So given the potential windfall of QSBS, it's really important to evaluate the eligibility of the company and its owners and its investors in getting QSBS. And it really requires some careful planning and coordination with your tax advisor, your legal team, whoever's involved with a company, to make sure that to the extent the company can qualify, it doesn't blow QSBS treatment through just not being aware of the rules. And just given that the upside involves a $10 million tax exemption, potentially more, you want to be mindful of it. One more thing to touch on here is that to the extent the company starts out as an LLC, the clock on the QSBS holding period, which I mentioned was 5 years, you need to hold the stock for 5 years to qualify. That clock starts at the time the LLC converts to a C Corp. So for any of you who have LLCs that you're thinking you're going to raise venture financing, you're going to ultimately convert to a C Corp, better to get that done sooner rather than later to start the QSBS clock. And another thing to keep in mind on LLC conversion that is sort of related is that if the stockholders' basis at the conversion of the LLC, the stockholders' basis at the conversion of the LLC is generally their fair market value of the LLC's assets at the time of the conversion. And so remember I said it's $10 million, the greater of $10 million or 10x your basis. There can be a scenario, and we've seen it, where if you're an LLC and you've signed a term sheet and there's a closing condition to the financing transaction where the LLC needs to convert to a C Corp before closing, the valuation of the company, the pre-money valuation of the company per the terms of the term sheet is at $5 million, and you convert pre-financing, your basis is now $5 million, or potentially the post-money valuation, and you'd be able to exclude 10x that basis from your federal tax. So on a sale of your stock, so it's huge, and something that really need to keep in mind and be aware of. It requires a lot of planning. There's a lot of uncertainty. Looking 5 years out in the future is difficult, but you don't want to get 6 years out and realize you could have had this huge tax windfall if you'd just thought about it a little and did some planning on the front end. Okay, so that was a little bit dense. Feel free to ask questions. Happy to do my best to answer them. I'm going to move on a little bit to IP ownership and IP protection as it relates to a startup. I know my colleagues Brian and Matt touched on a lot of this. There's a sort of a narrow focus that I'm going to talk about, and won't spend too much time on it. But there are two sort of problems that we see at early stages with startup companies. One is sort of a problem that I've heard people refer to as a moonlighting issue, and it's generally a lot of clients that come to us looking to talk about next steps to starting a new entity of their own, are currently employed with some other company. It's either another startup or it's a large company, and that they're trying to figure out how they navigate leaving an employer like, I don't know, name any large company in the Valley, and sort of working on the side to explore whether a startup idea that they have makes sense and can potentially get traction. And so it's important to be mindful of that, and make sure that if you're working on a startup while you're currently employed by another company, you're doing it in a way that does not compromise any IP you might be developing for your new project. And there's there are some California laws that that help in that regard. You definitely want to talk to a lawyer about it, but generally it's making sure you're not using any company materials to work on your new thing. You're not working, obviously you're not using any confidential information from your current employer, and you're just being very cautious about the when and where and how you work on your new project. So that's something to keep in mind. Every startup that we work with, part of our formation package includes an invention assignment agreement. And so when you start, when you form a new company, all of the founders should be signing confidentiality and invention assignment agreements. And we provide a form for the company to use with every contractor and every employee that they onboard going forward as they grow the business. And the reason for that, you obviously want an NDA in place, keep your information protected, and that's part of this form of agreement that all startups should be having people sign. The other really important piece that sometimes gets dropped is the invention assignment provision, and that just says that anything that the employee or contractor works on for the company in the scope of its employment or or engagement, if the contractor is owned by the company. And there are some ins and outs involved with that, but it's an important thing to have buttoned up with all of your employees and contractors, especially before you head into a financing transaction or an M&A transaction. Seen so many times in the middle of a financing transaction, the company realizes that they haven't been getting those signed. They've been getting an NDA signed, but that does not include an invention assignment provision. And then they have to go out to employees and contractors to get it cleaned up, in the middle of their financing transaction. And what happens with folks who are former employees or former contractors that you can't reach or are unwilling to sign. It can hold up your deal. It introduces a lot of risk to your investors. If those folks have not signed and are not willing to sign, then, and they have a potential claim on your intellectual property. And so a scenario you really want to avoid, and just make sure you're on top of that from the beginning. It usually gets resolved, but it requires a lot of effort and time and legal and company resources to get it done. And it's not a great place to be. But one of the more recent scenarios I've had like this was I was working with a company who was in the middle of a Series D financing, very mature, very well built out, process for everything, in-house CFO, in-house general counsel, and they, somewhere along the way, they had, their onboarding process had swapped in an NDA for their invention assignment agreement with the confidentiality provisions, and they had been getting everybody to sign an NDA, but not an invention assignment. And they had to go out to 150 people to get them to sign to get their deal closed. And so it held up the deal. It was, a sort of a black eye for the company. Got it done, but not fun. And so you should definitely try to avoid that. You ultimately can end up in a spot where you're in a negotiation with a former employee or a contractor, for a release in exchange for signing an invention assignment agreement, and it's negotiated, ultimately a negotiated exit where you have to pay for it, pay for the release, pay for the invention assignment, and so it can be expensive, just even beyond the legal and company resources involved to get there. Let's see, how much time do we have here? So just really quickly on due diligence, a due diligence process. After the term sheet is signed, after a term sheet for a financing transaction is signed, you'll receive a legal due diligence request list from the investors council. That really, it's a 10-page list. It's intimidating, super long, requests everything that could possibly exist. Organizational documents, bylaws, equity plan documents, all of your invention assignment agreements, confirming everybody has signed those things, that there's no claims on your IP, and the investor council is going to go through all of your material in excruciating detail, come back with questions on why you did this or that, where are things that seem to be missing, that sort of thing. And so to the extent you can be organized in advance of a term sheet process and have everything buttoned up, it's going to make your deal go quickly, smoothly, efficiently. It's going to cost you a lot less. It's going to make you look good to your investors. And so, something that you should be mindful of, I guess, setting up, we have some clients that just set up a data room on day one. They've asked us for, what does a diligence request list that we might see look like? and they just start setting everything up on day one, and then they have it ready to go when a financing kicks off. And that is a nice way to do it. It does save time, energy, money, headaches for the company's team, and makes life easier on us as lawyers as well. Let's see, I've got about 5-7 minutes here. Let's see if I can get through a couple more issues on financing quickly. Just seeing a question quickly. Let me go back. How do we protect ourselves on the front end of the moonlighting part of employment? We have a venture, for example, we have a venture. How do we make sure we do not compromise our rights to protect ourselves? It's a good question. It's sort of a sensitive topic, and it's you want to be making sure that you're if you're not in a position to talk with your current employer about something that you want to be doing on the side, you're not comfortable with it, you don't think they're going to be open to it, then you just want to make sure that you're doing it on your off time. You're doing it without your current employer's resources. You're not using any confidential information of your current employer. You're keeping just two completely separate worlds between the two. That's generally like high level what you want to be doing. I'm happy to go into more detail about it if that would be helpful. So let me talk really quickly, see how much I can get through financing. Obviously, this topic itself could take up, could be a 3-part series in and of itself. There are different forms of venture financing available. I think everybody is aware of that. Got angel investor financing, can do convertible financing, preferred equity financing. I think what I want to spend our last couple minutes on is just talking about the sort of financing that leads up to a preferred equity financing, getting yourself in the best position as a startup company to do a successful priced round with an institutional investor. And so I'm going to talk a little bit about safes and convertible notes. Those are the two sort of relatively easier documents in terms of paperwork involved to get you to a price round, and they're popular for that reason. They're generally known in the industry. It's less paper to get through to do it. You can get to term sheet to closing in a week or less, and so they're popular with startups for that reason. There are a couple things to be mindful and wary of. First, with convertible notes, they're still used quite a bit, even though safes have come into the picture in a pretty big way the last couple of years. For all intents and purposes, they're basically they're very similar. I'm not going to say they're the same, but convertible notes and safes generally help investors sidestep the process for agreeing on a valuation that is required for a price round. Often they both have valuation caps that really should be looked at more as like a discount. But the process for a convertible note or a safe really kicks the can of setting a valuation on the company down the road to a price round. The safes and convertible notes are shorter, simpler, and faster from start to finish than preferred financing rounds. One thing on convertible notes just to be careful about is that if your convertible note documents are not structured in a way to put all your investors on the same set of note documents, where you're having, for example, you're having each investor sign a note, but you don't have a note purchase agreement, and you don't have all the investors on the same note document or the same note terms, you can end up having to go to each investor that holds a note to, sign the financing documents at the time the preferred financing comes up and the convertible notes are converted into preferred equity. That can cause a problem for your preferred financing deal with your lead investor, because lead investors want to see that each of your note holders have signed the preferred equity documents and are on board with the transaction. They don't want upset note holders that are not happy with the preferred transaction, causing problems after closing. And so you want to make sure that your note holders are generally all in the same documents, all with the same amendment and waiver provisions that address how documents get amended, how the note documents get amended, how any note provisions might be waived, and that everybody is on the exact same terms so that there's privity of contract among all of the investors. That is something that has caused us a lot of problems in convertible note documents. On valuation caps, I want to touch on this real quickly. Valuation caps you see in both notes and safes, and they can be a problem. Although safes have been designed to address part of the problem, valuation cap, it doesn't address the problem completely. And you should look at a valuation cap sort of as price protection for your investors. And really it should be looked at more as price protection, but also a discount. It doesn't really place a valuation on your company itself. It's really intended to give the investor an idea of what their ownership is going to be. So valuation cap is a provision in your note or your safe that says the note's converted a discount to the next round of preferred stock, but the share price won't be greater than a share price that implies X dollar valuation cap. Maybe it's 5 million, maybe it's 7 million, maybe it's $10 million. And this may not be a problem if the cap is appropriate to the value and stage of the company, and the equity round follows quickly on the heels of the note or the safe round. And the amount you raise is relatively small. One of the biggest issues we see with convertible notes and safes is that they're so easy to raise money on that people just keep going back and back and back to more and more notes and safes, not realizing the additional dilution they're adding, and hurting themselves with that additional dilution, because the discount is 20%, or the valuation cap is $8 million. But as the company grows, that that valuation cap starts to get a little bit out of whack with where the company is, and so you end up in a spot where you're doing your preferred financing round, you're modeling out all your safe conversions or your note conversions, and all of a sudden you realize that you've taken on a lot more dilution than you really anticipated. So the fix for this really is, be very disciplined in how much you're raising on convertible instruments, whether it's safes or convertible notes. It might be a little more expensive to do a preferred equity round, but in the long term, if your company is successful, you're going to make that up on the back end in the amount of dilution that you save by doing a priced round rather than continuing to stack up convertible instruments with big discounts. And then the other piece is modeling it out as you go. So you have a capitalization table, you have a pro forma model that shows how the notes or the safes are going to convert on your preferred equity financing. And that way you can really understand what you're getting yourself into in terms of dilution. I've got a lot more I could talk about on this, but I think we're getting close to the end here, and I want to make sure there are a couple minutes for questions. Let's see. Looking at the list of questions here, can we add a clause in the NDA for the invention assignment while talking to prospective employees? Not really. You can have folks, you can have folks sign an NDA while you're doing an interview process with them. But until they're actually working for the company, there's no sort of invention or IP for them to assign quite yet. And it wouldn't really be effective until they actually do start working for the company. Follow-up question: how do you protect yourself if the corporation has a BYOD policy with computers? Yeah, so I think you would want to be using just a completely different computer, completely different system than the one you use for your current employer. So to the extent they do have a buy your own system, you'd have to buy a separate system, I think would be my advice on that, and just keep it as separate as you can. Any other questions? Hopefully this was helpful for everybody. Let's see, anything else? I think that's it on my end. Thanks, everybody. I really appreciate the time. Thanks to the team at Oracle, Rohit, I really appreciate it, and OneValley. Happy to address any additional follow-up questions that might arise as those things come up.
Thank you so much, Carl. And just a reminder for everyone, I think there were a couple questions we saw come through. Carl is available as a mentor on Passport. So you can always sign up. If you go to Carl's profile on Passport, you'll be able to book a 30-minute meeting with him if you need. So really appreciate that, Carl. It was really awesome.
Good. Happy to do it. Thank you all. I really appreciate the time.
Awesome. And so to finish up today, I just wanted to quickly say thanks again to Carl and Rohit for Oracle for Startups. And just a quick reminder that OneValley members can get up to 5K in cloud credits. And as Rohit mentioned, he's also a mentor on the platform, so you can book time with him in the mentor section as well on Passport. And the winner of today is Preeti. So we'll reach out to you to talk to you about getting you signed up for your 1 year of free Passport. And then finally, a few upcoming events. Tomorrow, we have an event with our partners at Bubble about how to build an MVP with no code. And then next Thursday, we'll be having our January pitch event, which will be Spotlight on Boston startups. So hopefully you can all join us. You can RSVP at our events calendar on Passport. So with that, that is everything. Thank you very much, everyone. And we hope to see you at one of our upcoming events.